right. You ready for a podcast?
Yes.
Sounds like you're dying.
I've had a cough for like 4 or 5 days.
All right. Well, I just hit the record button, so I'm finally ready for a podcast. Are you ready?
Yeah, I am ready.
All right, let's go. This is not what it's supposed to be. I am confused as to what is happening. Okay. Oh, nope, that was right. All right. Hi. Hello. And welcome to Learning the Law. I swear we've been doing this for a year now, and I still can't get it right. Hello and welcome to Learning the Law, podcast about all things legal with a focus on current events where we try to teach you things in an hour. Although tonight might be a little bit longer because it is the last podcast of the season of the year. My name is Ashley, aka Phoenix Nymphy, and my co-host, who is the man of the hour, my husband, Ron.
Hello.
This podcast is purely educational and should not be taken as legal advice. This podcast does not create an attorney-client relationship. This podcast is based on his interpretation of relevant law, and any opinions expressed are the opinions of the individuals making them and do not reflect the opinions of any firm, company, or other individuals. Ron is a licensed practicing attorney in the state of California.
Yes, I am, and have been since 1999.
And tonight, our podcast is affiliated with the with lawyer.com. With over 10 years of matching experience in technology development, lawyer.com is proud to make thousands of lawyer connections each week. Lawyer.com connects users nationwide with lawyers in all areas of law. Please use our referral link to help out the podcast and find yourself a lawyer in your area.
Yeah, it's a good system.
So tonight is our final podcast for the year, and then we will be back sometime mid-January. We haven't quite decided what date that's going to be yet, but if you missed the last podcast, we explain, all of that stuff. But we have wrapped up our Roe v. Wade mini-series. It was four episodes. If you are interested and want to listen to that, we highly recommend you going and listening to all of those episodes, because this one Ron wanted to talk about after we did the Roe v. Wade mini-series. So this is just a follow-up to that. As a reminder, Roe v. Wade is not just about abortion. It is about your personal privacy and bodily autonomy. And it is extremely important that we keep that, because if we don't, then it opens the doors for so much to happen to people in the medical field, outside of the medical field, so much.
That's very, very true.
I mean, just a side note, I just want y'all to understand what women have to deal with. Like in some states, in many states, it's legal for women to essentially be sexually assaulted while they're under anesthesia for surgery, because without our consent, they will have medical students come in and, just go up in our cervix and check everything out and give us non-consensual exams. That's the thing that happens. Yeah. There's a lot more that happens. So yeah, just to let you know, it's not just about abortion rights. It's about everything else as well.
So, we got a couple things to address first before getting into Planned Parenthood v. Casey.
All right, before we dive into this, we're going to talk about the most recent stuff, which is the Texas abortion law and what the Supreme Court said last night. So,
yeah, I'm getting to the article.
So last night, the Supreme Court, well, December 10th, I'm sorry, not last night, last week, the Supreme Court has left in place the Texas abortion law and basically said that it needs to go up and work its way through the system. And Gorsuch's excuse was, we've never preemptively stopped a law before, so we're not going to do it this time.
That is a falsehood.
Yes. But CNN has a very solid article about it. But one of the things that was really confusing me about this article, the question of whom providers can sue in the federal courts, while seemingly technical, could be hugely consequential in the abortion advocates' efforts to block the law in a way that will let abortions resume after 6 weeks. So it sounds like they're saying that abortion providers can sue in that particular thing, but I don't remember us reading that on the Texas abortion law. But it goes on to say, by limiting whom abortion providers can sue, the Supreme Court left open the possibility that the abortion providers may ultimately win ruling in their favor. But because it only blocks those select officials from enforcing the law, it won't be enough to allow clinics to reopen their doors. So I have read this multiple times and I'm confused because are they talking about countersuing? Like you cannot countersue the person who is suing you because you provided an abortion?
They're talking about suing in order to challenge the law itself.
Right.
And so the law was designed so that no one could be sued. So what the Supreme Court is saying is, no, you can't do that. They have the right to sue, to challenge.
Well, so the way the law was written was that basically they couldn't countersue.
Right, because we're not enforcing it. The private citizens are enforcing it.
Right.
So
there's no one for you to try to go after, essentially.
Yeah. So what they've said is that you have the right to file a lawsuit against state officials, and they've listed them out somewhere in the decision. I don't see in the article that they've listed out exactly who you can sue.
It should be in the law itself, shouldn't it? Or would that be separate?
No, it would be separate.
Because I haven't
have to be.
I haven't read everyone's dissent because they're all really long. And that would take so much time.
Yeah. What's important is on a 5-4 vote, they did allow lawsuits against certain state officials.
Mm-hmm.
They don't have any lawsuits against the private citizens.
Okay.
And in an 8-1 decision, only Justice Thomas said that he would have thrown out the right of the providers to sue.
Thomas.
Yes.
Why? Always. It's always him. It's always that guy. Always. He shouldn't claim himself. He should not call himself a Democrat. Because he's not.
He never has. He was appointed, I believe, by Bush Sr.
Okay. Gotcha.
Yeah. And basically the Supreme Court said they can't sue the state court clerks, which was one of the people that the abortion providers wanted to sue. And Robert said, court clerks don't enforce state laws.
But
that's true. They don't enforce any state law.
But the way this Texas abortion law reads, everyone enforces the law. So yes, They are enforcing the law.
But not in their role as a court clerk.
Oh, as
They only
okay,
yeah,
they're just doing the job.
right.
Gotcha. I see.
And now Gorsuch said the court has never recognized an unqualified right to pre-enforcement review of constitutional claims in federal court. Now, that technically may be true, but they have done it enough times that you would have expected something that was on its face blatantly unconstitutional, um, to have it an injunction against it while it goes through the court system.
So basically, they don't think it's unconstitutional, which is why they're letting it play out in the courts.
They are trying to let Roe be overturned without ruling on Roe being overturned.
Yeah.
So in essence, they don't have the courage to overturn it themselves outright.
They're cowards.
I mean, yeah. And you can see that they are more of a political entity than they would have you believe.
Absolutely.
And
which is why I say term limits should exist, but like I can see term limits being like 50 years or maybe 30 years.
Well, I have read an opinion that
somebody
Supreme
said
Court
they wanted
Justice
it
should be retired at 70.
Yes, absolutely.
So if they were appointed when they're 30, they get 40 years on the court. If they were appointed at 68, they get 2 years.
Right. Doesn't matter. Because I'm sorry, we don't need 100-year-olds making decisions on this stuff because you can barely stay awake.
Or they don't understand the technology.
Right. Like it's so yeah, I think term limits should exist, honestly. And I've always said that. I understand both sides, like why you don't, because you want to keep those precedents. But at the same time, I think that they can be with a specialized term limit. Not in the way of like Senate or whatever, which Senate term limit should be shorter, in my opinion. But and they shouldn't be able to come back. Like you got like 3 term limits and then you're done. Like that's it. Like you get 3 terms, that's it. You're done. You can't be in the Senate anymore because
That'd
at that
be 18
point,
years.
Yeah, at that point you've been there for 2 decades. You're too old now.
Generally, that's true. I mean, do you want, and I'll use an 80s analogy, do you want someone who can't set the time on their VCR making rulings on Facebook and social media platforms that they don't use or understand?
I don't want people who were alive during segregation making decisions anymore.
Even better example.
Just saying.
Yeah.
So that's so basically that's what's going on with the Texas abortion law.
Yeah.
Does it look like it could still be overturned? It's still up in the air. It really is. I mean, it's definitely leaning one way, but I don't think we can call it yet because there's still so much going on in the country itself. Like the next thing we're going to talk about is the holding the fact that they held Mark Meadows in contempt of Congress. Like this is very, very important and very huge. Heather Cox Richardson, for those of you who have never heard of her, is a historical what's the word? let me just look up her actual so I can explain it. American historian. There you go. She's an American historian with a focus in politics, and so every day she puts out a post about what happened that day. And today's was about the House Select Committee investigating the January 6th attack and talking about all of the stuff that came out from the text of Mark Meadows. Donald Trump Jr. was texting Meadows to get his dad to change, to say something. Why couldn't he text his own dad? Why was he texting Meadows? Maybe it's because his dad wasn't listening. So he was trying to get somebody else. You know, what Fox News personalities came out. It's come out that Fox News personalities, including Laura Ingraham, Brian Kilmeade, and Sean Hannity, which reveals how dangerously. This is her comment. I'm just gonna read this. This and Sean Hannity revealing how dangerously intertwined the right-wing media system is with Republican lawmakers. Quote, "This is hurting all of us," end quote, Ingram wrote to Meadows during the insurrection. So the texts leave no doubt that the White House knew what was going on, and yet he still waited hours to do anything. And there's stuff coming out that they were hoping for Antifa and anti-Trumpers to come into play so that he could have declared martial law and used the National Guard that was on standby against BLM and Antifa, even though they weren't there. They were hoping for another outcome, and when it didn't happen, their hand was forced. Is what it's coming down to. And it's just a wonderful I can't say article, but just a wonderful post. I've learned a lot from her as a political historian. And she's very, very well versed and just very intelligent. I was turned on to her by my favorite teacher from high school, because I'm still in contact with Mrs. Hamilton. So yeah. Anyway, is there anything more you wanted to talk about for the insurrection stuff?
You'll notice that they're starting to talk about dereliction of duty.
Yeah, again. Yeah.
Again. But we also talked about that before when we talked about his impeachment, and that's what he should have been impeached on.
It's the dereliction of duty. Absolutely. Yeah. So also just note, Fox News, Newsmax, and One American News, the right-wing media, did not cover the hearing today at all.
Yeah, they're not going to.
Because all of the stuff is naming those news media outlets and how much influence they have over the Republican Party.
Yeah. And none of the stuff that that committee is asking for is privileged in any sense of the word.
It's his personal text messages. It's his personal phone, his personal email. He never used work emails. He was using personal stuff, so it's not privileged information.
No. And the only one who can exert executive privilege is the sitting president.
Right.
You lose that privilege when you're no longer president. And, Trump's lawyers are asserting that he still has it.
But
no. They are losing every single court battle. Now, this will go to the Supreme Court, and we'll see how political they are.
Yeah. So this will
Now,
be very interesting.
what's his name? Our president Biden could s- could circumvent this in just one executive order. All he has to do is say, in the interest of national security, I'm releasing all of these documents.
Yep.
Done. Bam.
And I feel this is how I feel. If you were named and you were part of the people that knew that it was happening, you should not be allowed to hold office. Period. It should be an immediate release, immediately gone, and you are done. You are done. You cannot hold office anymore. But I realize you have to impeach them.
Yeah.
Which, I'm sorry, but there should be a law that circumvents the impeachment, where if you try to start a mutiny, you get thrown overboard and you're done.
Well, the DOJ, the Department of Justice, would have to bring some charges. Like treason, insurrection, sedition, something like that.
Mm-hmm.
And then the Congress can expel their own members.
But are they, though?
You're not going to get that in the Senate because of the filibuster.
Which needs to go away.
But you
Because
could get that.
voting rights is on the line right now because of the filibuster.
Yeah. You could get that in the House.
Yeah. Which could make a difference in a lot of stuff.
Yeah.
So that is everything that we felt was important for now, because we have been heavily focused on the Supreme Court and what the Supreme Court is doing. And, we started this podcast due to the insurrection. So the committee, everything that comes out of the committee is very important. So.
And it's also interesting that all those people on those news channels came out and said that Trump interviewed Trump, and he said he wasn't involved, and they agreed with him. But in private, they're texting Meadows to have Trump stop everything.
Right. So what else are they lying about?
Right. So that's the news there.
Yep.
Everyone should see what documents are being uncovered by that committee.
Yeah. Absolutely. So on to our topic of the week.
Yes. Casey, or Planned Parenthood v. Casey, which is the official title of the case that we were talking about today. Sometimes you will see it as Casey v. Planned Parenthood, but that's not technically correct. So, what is Planned Parenthood v. Casey? What does it matter? Well, Planned Parenthood v. Casey came about in 1992 when Pennsylvania decided that they would try and put restrictions on abortion. Not time restrictions, but basically 5 provisions to get an abortion. You had to wait for a certain time period after first requesting the abortion. You had to give your spouse notice. Minors needed parental consent. And, that you needed to be informed of what was happening to the fetus and how it gets, things like that. So this went up, and the informed consent was a woman must provide informed consent prior to an abortion procedure. The physician performing the procedure needed to inform the woman of the specifics of the abortion procedure including how it is performed, risk factors and complications, and information about the fetus that the woman was going to abort. In a lot of situations, uh, the woman who wanted the abortion was being shown ultrasounds of an abortion procedure. You know, how the fetus kind of gets sucked into a vacuum and, torn apart kind of thing.
Ugh. Yeah.
Then the spousal notice: a woman, if married, must have a signed statement that her husband knows and agrees to the abortion procedure.
Fun fact, did you know that if I wanted to go and have my uterus removed and have a hysterectomy, that I have to get my husband's support?
No,
Yeah.
didn't know that.
Yeah. You still have to say that it is okay for me to remove my baby box. Why? Because I'm breedable.
But if I want to go get my Van deferens snipped in a vasectomy, I don't have to tell you, right?
Yeah, you don't have to ask my permission, but I have to ask your permission. It's a little messed up, ain't it?
Yeah.
Again, it's not just about abortion. And I'm going to keep harping on this because it's not just about abortion.
The parental consent aspect was that a female under the age of 18 required the consent of her parent or guardian prior to the procedure. There was a certain exception that a minor could go get a judicial order in certain cases, such as incest.
Yeah. I was about to say, I understand needing parental consent. That's kind of what we need for most everything. I mean, you can't even get a tattoo without parental consent if you're under 18. But there are definitely circumstances like I get it. I see the reasoning why they should have parental consent, but I also see the reasoning why a 15-year-old shouldn't need to have parental consent.
Right. And so they did the provision where the minor could go to a judge
I
for
mean,
an
what if
order.
their family is extremely religious and are like, no, you're gonna, and are gonna force her through it, even though she doesn't feel that way? Would that
Right.
be considered under that? You know what I mean? Like, is that under that? Could that person get a judge to, you'd have to get a sympathetic judge.
Well, the thing is that person would then have a differing religious belief than the people making her decision for her. So would the parents' religious belief
Went out, or would that
supersede,
child's,
or
yeah.
would the child's? Um, that would depend on the judge.
And see, in that case, I think I mean, again, like I see both sides as to why parental, because you want the child to be safe as they can be, but if they're there by themselves, there's a reason why they're there by themselves. Because parental consent is probably not going to come.
Correct. Then
For
there
various
was
reasons outside of just incest.
a reporting requirement where abortion providers would have to take data and questionnaires from their clients, put it into a database, and do like a monthly report to the state, such as
Wait,
how
like
many,
violating hip? Oh, okay. All right. Sorry.
yeah, such as how many people came to this facility for an abortion, how many actually got the abortion, what their race was, what their ages were they single, were they married, all kinds of different report data that they wanted.
Demographic data is what they're asking for.
and financial too.
Yeah.
And basically, the court came in and said that women have a fundamental right to an abortion. It upheld Roe in that sense. However, the court overturned Roe's trimester framework. If you recall, before in the first trimester, the state couldn't regulate
Yeah.
any access, and then after in the third trimester, you had to have basically a medical reason
Yeah.
to have it, and then the second trimester was up in the air,
Mm-hmm.
and so they replaced the trimester framework with an undue burden standard, under which any abortion restriction would be unconstitutional if it were enacted for the purpose of affecting or placing a substantial obstacle in the path of a woman seeking an abortion.
That's so subjective.
Yeah.
That's
So
very subjective.
in that, which leads to things being up in the air now.
Yeah.
Um, and so in that sense,
Because
the
who
court,
determines the undue burden?
right?
I mean, if I get to determine the undue burden, good. That's because I'm the one who would be able to tell you what's a burden and what's not a burden on me.
Yeah, correct. And so what you had was and no one actually says this. This is my opinion. You had a significant overturn of Roe in 1992
Yeah.
by getting rid of that trimester framework. And so
Yeah.
in this case, they upheld 4 of those provisions as not being an undue burden. The only one they invalidated was the requirement of spousal notification. Everything else they said was a constitutional restriction on your fundamental right of getting an abortion.
Which were, can you name those again?
Informed consent,
Okay.
the parental consent, the medical emergency definition, and the reporting requirements. None of those were considered to be an undue burden to getting an abortion. The spousal notice was.
Yeah.
And so that is the standard now that all the abortion laws are considered. Is it an undue burden? And you can see that a lot of times it is an undue burden. And the
It
informed
isn't,
consent,
or it is.
it is.
Okay.
Yeah, a lot of times it is. Informed consent, which the court said is not an undue burden. But in order to get the abortion, you have to have a 24-hour waiting period after getting all this information. If you live, a couple miles from the facility, you could argue that's not an undue burden. Come back tomorrow, we'll do it. If you live 200 miles away,
That's an undue burden.
that puts a huge burden to come back.
Right.
And
Because
you may
if
not be
you-
able to come back.
And let's set up a situation in which that absolutely happens in this country. So that is a thing that happens not in the cities, not in, more urban areas. It's in the rural areas. So you live out in, well, let's go with Texas. You live in Texas. Do you know how many people don't live in the cities of Texas? Like, say you are this person who, this girl, right? This young lady who lives with her family on their, farm, right? And you are, God forbid, you're sexually assaulted and it results in a baby, or your father decides, I'm going to have a little fun tonight, and it results in a fetus, right? And you have to get to the closest facility that will do an abortion. That's not necessarily the closest hospital for you, because it could be a hospital that just doesn't have, because it's out in the middle of nowhere, it could be considered a Band-Aid station more than anything, because it's a hospital that just doesn't have that technology. And I'm saying this because I grew up with a hospital near me that didn't have that kind of technology. It was literally called a Band-Aid station. Everybody's like, don't take if you're gonna have a baby, don't have it there, because it's not gonna survive, or you're not gonna survive. I cannot tell you how many people have said that growing up. Okay. So we would have to go. My mother went and had me and my brother in Atlanta. And that is an hour and a half away from where she lives. So take that concept and that is when it's an undue burden. When you have to drive, and wait and wait and wait. And some people just don't have that ability to do that, because it exists. Those circumstances exist in this world. Whether or not you've experienced it, it exists, which is why it's an undue burden.
Right. So when we get to the opinion of the court, they, quote, uphold the essential holding in Roe. And that's what they said. And the essential holding consists of 3 parts. Women have the right to choose to have an abortion prior to viability, and to do so without undue interference from the state. The state can restrict the abortion procedure post viability, so long as the law contains exceptions for pregnancies which endanger the woman's life or health. And 3, the state has legitimate interest from the outset of the pregnancy in protecting the health of the woman and life of the fetus that may become a child.
Wait, say that last one again.
Yeah. The state has legitimate interest from the outset of the pregnancy in protecting the health of the woman and the life of the fetus that may become a child.
You mean that may become a money machine?
That is, the balancing that they tried to do in Roe.
Right. Again, it's a life that can give us money. That's it.
Okay.
It's literally it.
And the court,
because they sure as heck don't give you money to help you raise that child. I'm sorry.
No, they don't. Unless you are so poverty stricken,
unless you're destitute,
that you qualify even without having a child, and like a SNAP or EBT or Section 8 housing, things
that's why
like
a lot of people don't get married, because when they become a couple, when they get married, they now look at both incomes. Even though they are in a relationship, a committed relationship, they plan to spend the rest of their lives together, they don't get married because both of them don't make enough. And if they combine it, they will make enough to not be able to feed themselves.
Right. It's easier, generally speaking, it's easier to qualify for state aid if you're single.
Yes. And what I mean by they make enough to not be able to feed themselves, I literally meant what I said. Because so many of us have had to make the decision of rent or food.
Or medicine.
And when you have children in the mix and you both are married and you both bring in, $20,000, if he brings in 20,000, I bring in 20,000, that means that sets us at the poverty line, just at the poverty line of $40,000 a year together. But nobody can live off of $40,000 a year in this country. But according to some bullcrap statistics that the financial department has come up with, in that particular case, that person they make too much money for assistance. $40,000.
I will say, in some portions of this country, you can survive on $40,000 a year.
Not with children. Not with children.
The median income of a household in Georgia is $44,000. Can they survive in Atlanta? No.
But again, that means they are in those very rural places that are not
Correct.
near hospitals that can do abortions or near clinics that can help women.
Correct.
So, like, all you did was just help prove my point.
Right. All I was pointing out is that certain sections of this country you are able to survive on $40,000 a year.
Yes. But it's
California is not one of them.
No, it's very rare, and it is not a good life.
Right.
It's not a...
I didn't say it was a good life. I'm just saying you can survive.
Anyway.
You won't be homeless.
Yeah, you're just above homeless.
Yeah. Okay. And so what the court said, in addition, was that the fundamental right to abortion is grounded in the Due Process Clause of the 14th Amendment. So as you recall in our Roe miniseries, that there's an implied right of privacy. And that's what this is reiterating. And the court said, quote, if the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child.
Meaning because
if,
it is your personhood, you have the right to make that decision, and nobody else should have that right.
Correct. And the court further went on with another opinion in that Roe should not be overturned because of the stare decisis. And what stare decisis is a respect of preceding law, of prior law.
Okay.
And so while some of the justices would outright overturn Roe, and at this point in time, there were 5 conservatives on the court.
During
4
Casey?
conservatives. Yeah, 4 conservatives, 4 liberals, and 1 moderate.
Mm-hmm.
Who usually went with the conservatives. And so in this case, he did go with the liberals. The conservatives, all the conservatives said they would just have outright overturned Roe in this case. But the 4 liberals would have upheld Roe. But I'm not going to say the independent, the moderate respected the prior law and went with the liberals in this case.
So if this case had come before Roe v. Wade, we would not have had the right. Okay. If this case had come before Roe v. Wade, then the abortion situation would even be worse, and we would not be allowed any abortions at all.
Correct. Well, depending on what state you lived in.
Yeah. This would have opened the okay. Wow.
Yeah.
Wow. Which
And
is
so
funny to me because aren't the current Republicans, aren't they the ones who are all about less government? But in this case, they're saying the government should be invested in this. So doesn't that mean more government? Like, I'm so confused about the hypocrisy.
well, yeah. Hypocrisy is the politics of the day.
Like, but
So, and
seriously, like this. So the Republican Supreme Justices that said they would have not had have upheld this previously because this establishes the government's interaction with our bodies. This allows the government to come in and do crap with our bodies and oversee.
Right.
But the
And-
Republican Party is the party of less government.
no, not really. Different
That's what they
government.
say.
Oh, I know that's what they claim. They also
This,
claim that the
I'm-
Democrats are the tax and spend
Shut
party.
up. I'm trying to explain something. I'm trying to understand something. They're the ones. I'm trying to emphasize this, okay? They're the ones who are saying less government, but they're also the ones who keep okaying more government interference.
Yeah.
Thank you. Okay. Now, what were you saying?
The
The Democrats.
my train of thought.
The Democrats are supposedly
okay.
the tax.
The Republicans also say that the Democrats are the tax and spend party.
Not really, though. They're the ones who always raise the taxes.
The Republicans are also a tax and spend party. It's just that each one want a different tax and a different spend.
Yeah. Honestly, yes. And each one wants to tax a different, like the Democrats, liberals, the leftists want to tax the rich. The right wing Tea Party want to tax the middle class and poor. But the problem is there's no money there to tax. So
not anymore. We're taxed enough.
Yeah, we have been taxed to the point where we cannot afford it, which is why we need to tax the rich. Anyway, that's a different podcast for a different day.
So getting to stare decisis, people are going to think, well, they've overturned other things before.
Yes.
Okay, so now they go on and analyze the past judgments that were overturned, and the most preeminent one is Brown v. Board of Education, which everybody knows that's what integrated the schools.
Yes.
No more separate white, black schools.
Separate but equal. It's bull
right.
crap. It's bull crap. It doesn't work. It's bull crap.
Because it was never equal. It was separate, but it was never equal.
Right.
And they said there's a legitimate reason for overturning Plessy v. Ferguson was the separate but equal case. And it was that society's rejection of the separate but equal concept was a legitimate reason to reject it. This is where you have the societal evolution as the means of overturning even a law that could be 100 years old. But then they said there's a lack of need to overrule the essential holding of Roe because neither the factual underpinnings of Roe's central holding nor our understanding of it has changed. And there's no other indication of a weakened precedent to be shown.
Okay.
So,
can you kind of explain what that means?
Yeah. When Plessy v. Ferguson was enacted,
Yeah.
you know, that at that time, not everyone, but a majority of people agreed that there should be a segregation of black and white.
Well, the voters. Yeah, the white people.
Yeah. Yeah. And this, I believe it was late 1800s. But by the time the 1950s came around, society had changed to the extent that a majority of people no longer wanted or saw the reason for separate but
Mm-hmm.
equal, except certain places in the country. And so that societal evolution was good enough or a legitimate reason to overturn separate but equal and integrate the schools and other things like water fountains.
Which you
You
say
know,
this is the reason why you don't think they will ever overturn Roe v. Wade, because of the fact that the majority of society wants to keep it. Isn't this what you've said is
yeah,
why you don't think they will ever overturn it? Because they do actually look at the implications that it will cause in society.
yes,
Now, my
and
question is, do you
and
think that this particular Supreme Court will do that? Or is that your hope that they will do that? That they will look at what the implications will be?
it's my hope that they will stick with stare decisis,
Mm-hmm.
um, because if they get so political that they don't respect the prior law, then what is the law? The law is going to be whatever judges have been appointed by whatever president,
And at
and
that point,
you can change it from year to year. The law can change. So what you thought was legitimate one year, all of a sudden you could be thrown in prison for 15 years or
right.
so because now it's illegal.
Yeah.
You know, and in Casey they said, yeah, society has not changed to where um, the society wants the abortions outlawed outright.
Now, to the people who like to kindly remind me of how racist they are on TikTok, and talk to and say the majority of people want this to be overturned, I'd like to let you know that you are not the majority. I'd like to, I love to tell you this because it gives me such good feeling to remind you that you are actually not the majority. The majority, I want to say it was 68% of this country does not want to overturn Roe v. Wade, which means you are the minority. You
Yes.
are the minority, and you are holding our country captive. That should not be okay. The majority of the country does not think like cis het white men and their white ladies who hate themselves, okay? Y'all are the ones who keep upholding this crap, this awful, awful, awful legislation, and keep voting these awful people into power because you think you have power, but you don't. You don't. And now I'm patronizing you. Bye-bye now.
Okay. So now we get into the viability of the fetus because they're getting rid of the trimester uh, framework because they felt that the trimester framework was not workable. So they did a viability analysis instead. And as you recall, at the beginning of this country, abortions before the quote quickening were fine.
Right, which was at 16 weeks.
Right.
Which the fetus is still not viable after 16 weeks.
Correct. So they go through a viability analysis, and you find out that at this point in medical technology, a fetus could be considered viable at 23 or 24 weeks.
Which I believe is still medically what it is.
Right. And during Roe, it was 28 weeks.
Oh, really? I
Yeah.
think with technology now, it's 23 to 24 weeks.
So, um, they said at the point of availability, 23, 24 weeks, you can start regulating abortion.
Which I'm going to continue harping on these things that I keep saying. Once you are at that point, which is going to be your third trimester, you are less likely to have an abortion because you're carrying this child almost to term at that point. Once you are at 23 to 24 weeks, you kind of know that you want to keep that baby. We don't have late stage abortions as often as Republicans like to make you think. Usually when there are late stage abortions, it's because there is a problem with the fetus.
Yes, or the health of the mother.
Or the health of the mother, yes.
She's for an example would be she's developed gestational, I believe that's the term, diabetes.
You can have a pregnancy. You can still have
You,
the baby with gestational diabetes.
yes, you can, but in some situations it does affect the possible life of the mother.
Yeah. I mean, our TJ and his wife. I mean, what did he say that she ended up having? That came about because she had the baby. Like there are some.
Yeah, my understanding, she almost died.
Yeah, she almost died. There are things that happen to your body, and some things are triggered when you get pregnant. My sister-in-law also had issues, and things were it's like it flipped the switch, right? So, yeah, because it messes with your hormones and it affects and changes your body unlike anything a man is ever going to feel. A man is never going to understand how the body of a childbearing person changes when they are carrying a child. Which is why they should not be the ones making the rules about us.
I agree. And so this is basically this case basically changed Roe.
I think it would be good to have the viability thing and the trimester situation. I don't think that they did anything really that different from Roe v. Wade. They extended it a bit, actually.
Yeah, they did.
But yeah, I mean, it's still, trimesters. It's easier for a lot of people to understand in trimesters, I think.
Right. A trimester approach is very rigid.
Yes.
A trimester is the first 13 weeks period.
Right.
Viability, all of a sudden, viability is in the Texas law, basically, cardiac activity.
But that's not viability.
It's not, because cardiac, if you're an adult and you have cardiac viability but no brain function, you are considered dead.
Yes. And I said last podcast, your brain is the last thing to develop. Your brain is still forming when you are a child and into your 20s.
Right. So, as I said in Roe v. Wade, you can change the term of what an abortion is. It's not an abortion. It's the termination of a brain dead pregnancy.
Oh, yeah, okay. Yeah, I remember when you said that.
that has never been addressed by the courts. That's just my personal opinion. And there you have it in a nutshell, is Planned Parenthood v. Casey.
So why is Planned Parenthood v. Casey so important right now?
Because of the undue burden standard.
So we were talking recently about what they're trying to do is not overturn Roe v. Wade. They're trying to overturn Planned Parenthood versus Casey and then get to Roe v. Wade, correct?
Right.
So what so specifically what is it? So it's the undue burden process. That is what the Texas abortion law is attacking, correct?
Correct. Is being sued for abortions for $10,000 a pop an undue burden?
Why would it be? You chose to sue somebody. You're the one who gets to choose this burden.
No, an undue burden on the person getting or providing the abortion.
Oh, abso-fucking-lutely. Oh, whoops.
Well, there you go.
I'm gonna have to
edit
that one. I've been doing so good. The last podcast, of course. What number? Let's see. Where are we at? We're 1:05. Okay.
Yeah. So I think that's an hour and 5.
I'm sorry, an hour and 5. Yes, not 1:05. We've been here way longer.
Then, when you overturn this viability and undue burden, then you can go and overturn Roe.
Yeah. Because Planned Parenthood versus Casey solidified Roe v. Wade. That is why they are attacking it first. Basically, trying to... Yeah.
And you cannot, as you can see from some of the things said here in this case, you cannot overturn Roe without finding that there is not an implied right of privacy.
Yeah.
And once that right of privacy is gone, everything is thrown out the window.
Which is what we said, which is what we discussed in the last podcast. Yeah. You know, if Roe v. Wade is overturned, we no longer have our implied right of privacy, which means the government can come in and stop us from doing anything. And LGBT rights, civil rights can easily get overturned.
Right. Not only that, do you have a right of privacy on your cell phone? It's, right now, yeah, they need a warrant to get your cell phone records.
Yep.
It doesn't even have to be a pre-existing condition. It could just be something you're more likely than not to develop in your life.
Yep. So, yeah. This is, again, why it is important that Roe v. Wade and Planned Parenthood versus Casey not be overturned.
Correct.
Because this will also affect cishet white men.
Well, I think the number one person that, should be sued in these cases, if it's going to be upheld, is the guy that got the woman pregnant. Because that's the fundamental reason for an abortion to begin with.
I actually want to know why the father is never attacked. No one ever goes after the dad. A woman doesn't get pregnant on her own right now. Although there's technology now where women are able to get themselves pregnant. Not get themselves pregnant. They have to go, to the doctor, but
it's a modified in vitro.
Yeah, it's a modified in vitro process. So
I believe it uses one egg and one other egg.
It also uses bone marrow
and stem cells.
Yeah, like it's It's pretty cool. It's very, very cool stuff.
Don't fall under the myth that all stem cells come from fetuses.
Yep.
That's not true.
Yeah. Also, stem cell research is actually very important and very good for us. So, did you know that stem cells also come from the placenta?
Yes.
Like when you have a baby, the placenta comes with the baby. Stem cells are in the placenta. Like, so, like stem cells don't just come from fetuses.
Right, but a lot of people believe that because they don't understand science.
Well, they also won't go get COVID vaccines, so
I have to state for the record, the Earth is not flat.
yes. But I think that kind of wraps us up.
Yeah, it does for the year.
Yeah, we will be back with lots of exciting things next month. So
yeah, we may even start to get some decisions from the October arguments from the Supreme Court in January.
So
no guarantees, though.
Yeah, so there will be. So everybody have a happy holidays. Enjoy time with friends, family, whoever. Don't stress out. You know what? Don't feel bad if you don't want to go to that family function. If it makes you stressed out, don't do it. You don't have to. And remember, your rights are very, very important. And you deserve to have the ability to know what's going on in your life. You have the right to bodily autonomy. You are loved and you are so worthy. Anything else?
That's all from me.
Happy holidays, everyone. Thank you so much for listening to Learning the Law. If you like this podcast and want to hear more, don't forget to like, subscribe, follow, and share in all your favorite places. You can find it hosted live. No longer on Twitch. I need to change that. You can find it hosted live here on YouTube. Oh, this is my old one. Hold up. I can do this. I can do this. I can do this.
We're doing it live.
We're doing it live. I accidentally deleted something. And I'm like, wait, hold up. This is not the same. Gotta love it. I haven't learned my script. Anyway, thank you. If you like this podcast and want to hear more, don't forget to like, subscribe, follow, and share in all your favorite places. Don't forget to follow us on Twitter at Learning the Law, Ron at Necrokijo, that's NECROKIJO, and me at Phoenix Nymphy. If you have any questions, please tweet, comment, or you can even email us at 2lazydogsmedia@gmail.com. That's 2 as in written out, TWO. This has been a 2 Lazy Dogs Productions.
Happy holidays, everyone.